Imagine if the most popular rifle in America, the AR-15, was declared outside of the protections of the Second Amendment. What would that mean for millions of Americans across the nation who owns one of these rifles? And that's not a hypothetical, that question is currently in front of the Supreme Court. So let's break down what is happening currently in this critical case. Now, before we jump into this video, I want to ask you guys that if you want to support this channel for free, if you enjoy this type of two-way content, please consider subscribing to the channel. That of course helps the channel to grow. And then also just double check to make sure YouTube has not unsubscribed you, because they love to do that, especially on two-way channels. I also want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. Their culture is unmatched. It bleeds into everything that they do. So if you want great supplements and you want to support a pro-freedom, pro two-way company, check out 1st Phorm using the links down below. And if you order something $100 or more, you can get free shipping on those items. And also they have a money back guarantee, so you can get your money back if you're not 100% satisfied with what you order. As I mentioned in the intro, in this video, we're going to be discussing a critical rifle ban challenge that's now seeking Supreme Court review. This case is called Viramontes versus the Cook County. And in this case, the petitioners are individual citizens in the state of Illinois, in that Cook County area, and they're challenging this restriction along with two-way organizations like Second Amendment Foundation. They are challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons. This case tries to leverage the recent statements made by Justice Kavanaugh after the Snope rifle ban denial, which happened actually last term. And in that denial, Justice Kavanaugh stated that the time will come soon that they would need to take up a rifle ban, and he indicated that could happen in a term or two. The plaintiffs now push this case as a vehicle to essentially fulfill that promise. And now also in this Supreme Court cert petition, other organizations in other states like ANJRPC, who are currently also challenging a similar state ban in the state of New Jersey, they are now going to the Supreme Court in support of the plaintiffs here, saying that it is time for the Supreme Court to grant review to one of these rifle ban cases and end these type of state bans nationwide. Now, here's how this case essentially got here. In 2021, the lawsuit was filed in a federal district court in Chicago, and the petitioners challenged the county's ban under the Second Amendment. Now, in 2024, while the case was pending, Illinois passed a statewide assault weapon ban overlapping with the county's ordinance, and the statewide ban there is the Protection of Illinois Communities Act, also known as PICA, which we've talked about heavily on this channel. Now, around the same time, the 7th Circuit decided a case called Bevis versus Naperville, and they essentially upheld the Illinois law, claiming that AR-15s were too militaristic to be protected arms. They claimed that these types of rifles were useful in military service, and therefore they could be restricted or potentially outright banned. The district court issued a summary judgment in favor of the county, and then in 2025, right after the Snope petition was denied, the 7th Circuit affirmed that lower court ruling. It leaned heavily on the Bevis ruling, treating AR-15s as essentially the civilian version of an M16, and they said that they are militaristic weapons, and therefore they're outside the protections of the Second Amendment. That has now led this case to seek Supreme Court review on the final merits, because remember, the district court issued a summary judgment in favor of the county and their ordinance. In this petition, the petitioners are asking the United States Supreme Court to step in, resolve these conflicting approaches in the lower courts, and declare once and for all whether Americans have the constitutional right to own these types of rifles. The petition argues that the circuit courts are split and deeply confused on how to apply Heller and Bruen. Now, in my opinion, I don't think that these lower courts are confused. They're simply just outright defying the Second Amendment and what the Supreme Court has said in some of these cases like Heller and Bruen. The petitioners here say that the Supreme Court needs to clarify that all firearms, essentially guns, including semi-automatic rifles, are arms under the Constitution. In the Supreme Court petition, they introduced surveys, production numbers, and sales data to show that tens of millions of AR-15s are in circulation and they're owned and possessed by law-abiding individuals. They point out that Cook County and the 7th Circuit rely on the idea that AR-15s are military firearms, but Heller never said, firearms and, weapons can be banned simply because they're useful in military service. Instead, the only historical limitation, potentially identified in some of the Supreme Court precedent is potentially restrictions on weapons that are both dangerous and unusual. They point out that AR-15s, by contrast to dangerous and unusual weapons, are very common, they're in common use, they're popular, and overwhelmingly used for lawful purposes. The useful and military service analysis that was used by the Seventh Circuit and other courts was never part of Heller or Bruen, was never mentioned in that type of analysis, and therefore it should be outright rejected and struck down by the Supreme Court. They also point out how all of these laws have been passed in direct defiance to Bruen. Some of these states passed them soon after Bruen, essentially to stick a middle finger up to the Supreme Court and what they said in that new ruling. And because of all of this, they also point back to what Kavanaugh stated recently in the Snoke denial, and they say, you promised that you would review one of these rifle ban cases in a term or two. Well, this is the perfect case, the perfect vehicle dealing with a county ordinance that's banning these rifles and these types of items, and there's a similar state law that was used to uphold this, and this is on the final merits dealing with a summary judgment motion that was granted, and this is the perfect vehicle, the perfect case to finally address this issue. And this is actually pointed out recently by another toy organization, ANJRPC, in the amicus brief that they filed to the Supreme Court in this case. They are currently fighting a similar state ban in the state of New Jersey, again, that bans rifles and magazines. And in the amicus brief, they argue that this case should be granted review by the Supreme Court because it would impact their challenge in another jurisdiction and dealing with another state ban, but also address all the other state bans that have been litigated, gone up and down, back and forth for years. And essentially, we've all been waiting for a very long time for the Supreme Court to finally address this, and this is the perfect case. They state that just a mere 7 days after Bruen was decided, the state of Delaware on June 30th, 2022, enacted its own ban on these commonly possessed semi-automatic arms. This was followed in rapid succession in 2023 by Illinois and Washington, and of course, the passage that same year of the very Cook County law that is the subject of this petition. They point out that states are simply not getting the message, and until the court squarely takes up this issue, the defiance will continue. ANJRPC points out in the amicus brief that prior you had justices like Thomas, Kavanaugh, and others say that it's time potentially for them to review rifle bans and magazine bans. ANJRPC states that the time is now, and this is the case that they need to review. They conclude their amicus brief by stating that the record in the New Jersey litigation illustrates the constitutional consequences of allowing the majority of other courts hearing these cases to run off the rails with the same type of interest balancing approach that persisted for 12 years prior to Bruen. Accordingly, the court has an excellent vehicle in this petition to prevent such derailment now. So from New York to California, this case in front of the Supreme Court seeking review is very important, and it's needed to strike down these state bans. To this point, the Supreme Court has avoided the rifle and magazine ban question like a plague. However, we do know that Kavanaugh stated last term that it's going to be time soon for them to address these rifle bans, that they would do it in a term or two. Now, we're going to find out very soon if Kavanaugh's promise was an empty promise and if they are actually going to review this type of rifle ban in a term or two. So again, a very critical case is currently pending in front of the Supreme Court, seeking Supreme Court review on the final merits of a case. And again, this deals with a rifle ban. We're going to see how this develops and maybe if the Supreme Court finally decides to take up this critical issue. But as we get more information, as this develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there, we have a lot for you guys if you want to support the channel. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.